Okay. Well, we're streaming live. We're here. All right. So, first thing is what we're going to do. By the way, if you guys want to join the live and be in the chat, go to my Telegram channel, click the Zoom link, and join in from there. Otherwise, TikTok is just running so that just to alert people that we're live over on Zoom and YouTube via Telegram, because for some reason Telegram is glitching out like crazy, and it doesn't seem like YouTube is chat. Go to my YouTube is not glitching out, so we're using Zoom and YouTube. All right, so go to my Telegram channel, go click the link in the Zoom link in Telegram, and you can join me live on YouTube in the Zoom meeting. All right, that's where we're going to be. By the way, we shut off a lot of things, so don't get upset when you join Zoom because of some of the other nasty interruptions we've had in the past. All right, so we've had some interruptions from some nasty people in the past, but I will let people in and people can talk and stuff like that. But we're going to be very a little more cautious about what people can do in these things, right? Because of oh, why did they make him the speaker? Okay. Let's do a gallery, I guess. Anyway, so yeah, I would say go ahead, Telegram, click the Zoom link, join in on Zoom. We can have a conversation there. All right, and we'll discuss whatever you guys want to talk about today, because I was doing something on Telegram for about 15 minutes, and then I was getting complaints that it was all choppy and wasn't coming out, and I said forget it. And then I was like, well, I'm done. With that whole topic, I kind of like exhausted it. I mean, maybe not. You know what? Let's go into it. Let's do it. Let's do it. Here's what we're going to do. I'm going to open up the waiting room so everyone can join in. But if you want to speak, all you got to do, put in the chat that you want to speak. Okay. And then we'll let you speak. But yeah, I got full control of this now. But guys, if you're on TikTok, again, go to my Telegram channel, okay? Go find the link, the Zoom link in Telegram, okay? Join the Zoom link, and you'll be added in automatically now. So I took the waiting room off. But here's what we're going to do. All right. Where is this? Is this it? This is not the one. Is it this one? All right, yeah. This is the one. We're doing this, boy, everything. Why do they do that? Okay. This document gets a little weird sometimes. There's like a lot of space in there. All right. So good morning. Good morning, people. We're going to do this. And on you guys who are live on YouTube, here, let me pull the YouTube thing to the side so I can see the YouTube comments. And then we can I can talk to the guys who are on YouTube. Okay, so what we're doing is this is an analysis of the U.S. Constitution, and again, what this analysis is this was. I'll go up to the top. I'll show you where this is. All right, an analysis and interpretation. Okay, analysis of cases decided by the Supreme Court of the United States to June 28th, 2002. Okay. So everything after that, it's not in here because this document's a little old. All right. It's like 23 years old. 23 years old. It's old enough to go grab a beer. All right. So here's what we're going to do. All right. We got Amendment 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people. All right. Oh, where's my thing just died. Oh, my mouse died, so we'll have to give it a minute. Anyway, it's the right of the people to, you know, peacefully assemble, right? They can petition their grievances and stuff like that. My mouse died, so I got to charge it, so give me a minute. But in the meanwhile, we're going to look at this court case. It says in Dillon v. Gloss, the Supreme Court stated that it would take judicial notice of the date on which a state ratifies a proposed constitutional amendment. Accordingly, the court consulted the state's journals to determine the dates on which each house of the legislature of certain states ratified the 18th Amendment. It therefore follows that the date on which the governor approved the ratification, or the date on which the Secretary of State of a given state certified the ratification, or the date on which the Secretary of State of the United States received a copy of said certificate. All right, so, okay, when the date is not available, the date given, this is just about ratification stuff. All right, so, brackets enclosing an amendment number indicate that the number was not specifically assigned in the resolution proposing the amendments. It will be seen accordingly that only the 13th, 14th, 15th, and 16th amendments were thus technically ratified by number. All right. The first 10 amendments, along with 2 others that were not ratified, were proposed by Congress on September 25th, 1789, when they passed the Senate, having previously passed the House on September 24th. All right. So 13, 14, 15, and 16 were ratified by number. Sounds like they had a plan for those 4, didn't they? So the 13th Amendment, right? And this is really interesting. Just like a little side note here. The 13th Amendment, right, is like, it's almost like an independence declaration, right? They're declaring that certain people will be free now, okay? And the slavery and involuntary servitude is no longer legal. Okay, so it's now illegal. The 14th Amendment gives those newly freed slaves citizenship on a federal level, which the founding fathers never wanted. They did not want federal citizenship. Okay, and earlier on, if you read earlier in this document, it really explains why without saying it flat out, but it says earlier in this document, it says that that they wanted the federal government to have a little bit more power, but the whole idea was not for it to have its own citizenship, because then it would be like an infiltration of their citizens, because it's supposed to be United States, right? The idea was that each state was supposed to be an independent nation, all joined by this one constitution. And that what they would do, that basically the federal government was going to be composed of representatives of all the different states. So what happens is, if those representatives now have their own citizens, it's like it's its own nation, right? Outside of the 50 states. At the time it would be 13, but that means that this federal government now has its own citizenship. And that's not the intent behind the Constitution. That was never the intent. Okay, it was to have that federal citizenship. It was supposed to only be state citizenship. Okay, but federal citizenship has created a world of problems in this country. Okay, it's done so many bad things to our country because of the fact that a 14th Amendment citizen is beholden to the federal government. Good morning, guys. Remember, by the way, if you're on TikTok, real quick, go to my Telegram channel. There's a Zoom link. You can join in on Zoom over there. Okay. I charge this thing a little bit. Let's see if that's enough. And you guys can join on Zoom. Hey, Joe, I got something from my case. Okay. If you want to speak, he's not here. He said something and he left. Okay. I was going to unmute him, but all right, fine. Brackets are closing amendment number was not specifically assigned in the resolution proposing the amendment. All right. So the first 10 amendments, along with 2 others. No, all right, we already read that. Now, Amendment 2, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Right, and this is where all you get those, like, the people who are anti Second Amendment, all the Second Amendment anti people, they'll tell you right here, oh, see right here, this is the people they're referring to. The right of the people. What about we the people at the beginning, at the preamble? What are you talking about? These guys don't know, they don't understand. They think that this thing is just sitting right there, contained within itself and has nothing to do with any other part of the Constitution. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Not the people of the militia. Everybody. We the people. And the posterity, which is all the future people. So this is the kind of crap that they're doing, because they don't know. These guys are not sharp. All right. Well, they may be, because a lot of people fall for it, right? So they're sharp enough to fool all the dimwits, but in actuality, anyone who can rub two sticks together and create fire can figure out that that's all a bunch of BS garbage. Okay, here's Amendment 3. All right, no soldiers shall in the time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Now, the General Orders 100, the Lieber Code, actually kind of did away with this to some degree, not totally, just a little bit. Go to my profile and click the link in my profile. Okay? And you'll find the Telegram link in there. That's where the Telegram link is. Just go to my profile right here on TikTok and go find there's a Linktree link, and go look for the Telegram, and you can join in and be a part of this. All right. Now, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, there's a lot of issues with this amendment today, and I'd like to see if they actually interpret that in here somewhere. Talk about the 11th Amendment. Why can't we do... Okay. Let's see what they did for the 14th Amendment. All right, the 13th Amendment was proposed by Congress when it passed the House, right? Having previously passed the Senate. Okay, it appears officially in 13 Stat 567 under the date of February 1st, 1865. Ratification was completed on September 6, 1865. Legislation, okay. Amendment there being, okay. The several state legislators ratified the 13th Amendment on the following dates. Illinois, okay, we don't need to know all that. We just know that they did. All right. Florida again ratified it there upon its new adoption of a new constitution. New Jersey, after having rejected the amendment, New Jersey likes its slaves. They still do to this day, I'll tell you that. In fact, New Jersey, I think, is one of the last northern states to accept or to ratify the 13th Amendment. They didn't want to let it go. They took their sweet time doing it, and they still had slaves even after that. There's places around here that show like slavery in this area from that time period, how it was still going on. What's interesting though is that the slaves all had names and stuff like that, and they had stories behind it. It's actually kind of interesting that they documented what the slaves' lives were like, and who they were, and who their parents were, and their children were. It's pretty interesting. All right, now. The 14th Amendment was proposed by Congress on June 13th, 1866, when it passed the House. It appears officially in 14 Stat 358 under the date of June 16th, 1866. I like this. Look what it says here. Ratification was probably completed on July 9th, 1868. Probably. Okay, when the legislature of the 28th state... Oh, where'd it go? South Carolina, Louisiana approved the amendment, there being that 37 states in the Union. However, Ohio and New Jersey had prior to that date withdrawn their earlier assent to this amendment. Accordingly, Secretary of State Stewart on July 20th, 1868 certified that the amendment had become a part of the Constitution if the said withdrawals were ineffective. 15 Stat 706 through 707. Congress on July 21st, 1868 passed a joint resolution declaring the amendment a part of the Constitution and directing the Secretary to promulgate it as such. Boy, it sounds like they really were playing some shifty shit here to get this thing on, right? So July 28th, 1868, the Secretary certified without reservation that the amendment was part of the Constitution. At the end time, 2 other states, Alabama and Georgia, had added their ratifications. Okay. Uh, the several state legislators ratified the 14th Amendment on the following dates. There we go. Now, mind you, I'm going to show you like these are all the states that ratified it, but I'm going to tell you something here. If you don't know what happened, then you don't know what happened. It's real simple. But here's what's going on here. The Reconstruction Acts, what it did was it allowed the federal government to come in and remove all the state legislators, citing them as insurrectionists and rebels, or rebels, really, rebels and insurrectionists, and remove them from office. And what it did was they put in their own people, and their own people then ratified it. So was this actually a ratification that was done willingly by the state and the representatives of the state? No. In fact, the president at the time even complained about the fact that this 14th Amendment never even came across his desk. So how could he has veto power, and it was denied to him to even look at this thing. And when he made the complaint about it, you know what they did? They impeached him. Isn't that interesting? They impeached the guy. He became the first president to ever be impeached. Andrew Johnson. That's who his name was. The amendment was rejected and by Kentucky. Maryland ratified this amendment. Look at this. Maryland and California ratified this amendment in 1959. Wow. You hear that? So what are they telling you here? Like, look at all the crazy shit going on here. A lot of these states really were rejecting this thing, right? After rejecting the amendment, right? Ratified it again, 1870. They rejected it. They rejected it. Look at all these rejections. Why were these people rejecting the 14th Amendment? Because they didn't want to give up their citizens to the federal government. What was the federal government doing to the states? They were saying, we won the war, now we're taking the spoils of the war. We're taking your people, and they're going to become ours. And anyone who can't see that, like really has not done enough research on this. Go read the Construction Acts. I read the entirety of the Reconstruction Acts up on Rumble. So watch all. There's I think 3 videos of it where I read the entirety of it. And when I wrote to the Library of Congress and asked them if the Reconstruction Acts were ever repealed, they told me no. So that means they're still valid on the books. So that means the Reconstruction Acts are still in operation today, which is why we still have the 14th Amendment. All right? And this is why all this crap was happening. Most of these guys, they were just kicking out their people and putting in their own people into the state. It was a whole, that's why it's called the Reconstruction, because they were reconstructing the states, right? And they were forcing the states to come up with new constitutions that would make it easier for them to be dominated by the federal government, essentially. All right. Interesting. All right. 15th Amendment. By the way, I did a video breaking this down. I did a video on this breaking down the 13th, 14th, 15th Amendment were actually a whole brand new constitution for U.S. citizens. And it follows the same line that the colonies followed in order to create the United States of America. They did the Declaration of Independence. You have your 13th Amendment, right? You're free now. Okay, then what they did is they made the states independent and sovereign and with their own citizens, right? That's your 14th Amendment, right? The federal government's now its own country with its own citizenship, right? The federal government was never supposed to be a country. It was supposed to just be an organization for the purpose of keeping the states, functioning together as a union. That was the whole idea. Okay, it's supposed to do like international trade, work out the treaties, but it's all supposed to be from the state citizens coming in together and going, this is what we want, and then working out a resolution between what all the states want. That's why there's like a 2/3 vote, because in the Articles of Confederation, it was like if one state said no, that was it. No, it wasn't happening. Okay, so that's why they changed it up. But this is what this does here. Income tax started before World War One, right? It was right before it, but they didn't really start pounding that thing until afterwards, like 1913, which is pre-World War One, was the 16th Amendment. But we'll look at it actually. Let's go look at it because we're right here. No, that's not that one. Oh, this is 18. Yeah, yeah. Can't drink, people. No drinking anymore. That was they realized they fucked that one up pretty bad, didn't they? All right. The Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. So even the 16th Amendment flat out tells you, and look, notice that they don't have a breakdown for the 16th Amendment. They don't want to talk about that one. They just talk about this here. But yeah, it doesn't say that citizens of the state have to pay taxes. It says that the several states have to pay taxes. So if the states have to pay taxes, and it has to be without apportionment, okay? Meaning that has to be like a flat tax, right? So the income tax, right, where it is apportioned is actually not the 16th Amendment taxation. It's a voluntary agreement that you made with the IRS to have them take money out of your paycheck every week, okay? And if they at the end of the year said that they didn't take enough out, then you got to give them more. And that is not what the 16th Amendment says that they can do. So it's all BS when people say this. I keep seeing this lawyer on TikTok over and over again talking about how if you don't pay taxes, you're going to go to jail. Like, lady, I haven't paid taxes since 1999. Where the bars? Where the cuffs? I got no silver bracelets. So, they just say all this crap to scare people. Notice that lawyers are really fear mongers. Oh, if you don't do this, you're going to go to jail. Oh, if you don't do that, you're going to go to jail, right? You're going to get in big trouble, right? And I'll be honest with you. I'll tell you, if you screw around with this without knowing what you're doing, yeah, you're going to get in trouble. Okay? You will get in trouble if you don't know what you're doing. So don't do anything until you really know for sure what you are doing. Plain simple. Okay? By the way, for everybody who's on TikTok, if you would like to join in on the call, we are live on YouTube, okay, via Zoom. Go to my Telegram channel and click the Zoom link, and you'll be added on to Zoom automatically. All right. And if you're on Zoom and you'd like to speak, go ahead and put a request in the chat that you want your mic open to talk. I unfortunately have to do it that way since the scammers like to come in and share dirty stuff on the live YouTube stuff. So unfortunately can't do that. Now let's go down here. We're going to scroll down a little bit more because this is a big document. All right. And there's a lot of stuff in here, but those are all talking about the ratifications. But I just like to point out that it says probably when they're talking about ratifying the 14th Amendment, it was probably ratified. But they don't even know. They don't even know. They can't, oh, it was probably ratified. I like how they slipped that in there like that. Oh, it was probably ratified. Oh, yeah? Greetings, Steve. I see you on YouTube there. And hello to everyone who joined here on Zoom. But here, let's go. Look how big this document is. It's freaking huge. All right. But we're just going over some of that stuff. And then here, let's go to, is there a table of contents? I don't think there is one. Maybe there is. Oh, no table of contents. That's what makes this hard to read. Yeah, see, it just goes right into this. Is there? Nope. Historical notes. Yeah, there's the Constitution. And we're going to jump down a little bit here. So, guys, I'm going to share this document in my Telegram group so you guys can study this stuff because this is important stuff to be reading. But right here, this is about legislative powers, okay? And that might be a good thing to study because what you want to do is look at what legislative powers do they actually have and what they don't. And this is all court interpretation of it, right? So we can go in like judicial enforcement. All right. Political branches have contended between themselves in application of a separation of powers doctrine. Many notable political disputes turn on questions involving the doctrine. Inasmuch as the doctrines of separation of powers and of checks and balances both require both separation and intermixture, the role of the Supreme Court in policing and maintenance of the two doctrines is problematic at best. And indeed, it is only in the last 2 decades that cases involving the doctrines have regularly been decided by the court. Previously informed understandings of the principles have underlain judicial construction of particular clauses or guided formulation of constitutional common law. That is, the non-delegation doctrine was from the beginning suffused with separation of powers premise. You know what I just realized? I'm going to share this Zoom link. Let's share the Zoom link. I have it somewhere else. Hold on. All right. I like how somebody comes in and puts all this crap in here. I'm gonna delete this because I'm doing something, and I hate deleting stuff off of. But you know what you're doing is you're burying the freaking Zoom link that I shared with everybody by adding all that text that people could just go see later on. All right. It's not that important. Okay. I know what you shared. I'm not going to say what it was, but I will tell you that what you shared didn't need to be shared, really. So, give me a chat. Let's see. Okay. All right, fine. Now, here's what we're going to do. You know, this just gave me an idea. I think I'm going to try something different from now on. But this way, I don't have to worry about the scammers. Okay. Ho, 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 ho. I got a great idea. Okay. Yeah, I'm going to do something a little differently from now on with these meetings. But remember, if you're in the meeting right now and you do have something you want to say or ask or add, you can always put a request in the chat, and then I'll unmute you and we can talk. All right. The effective demise of the doctrine as judicially enforceable construct reflects the court's inability to give any meaningful content to it. On the other hand, periodically, the court has essayed a strong separation position on behalf of the president, sometimes with lack of success, sometimes successfully. All right. All right, let's see. Good morning, everybody. This legislative, this is a huge document, by the way. I'm showing you guys how big this thing is. All right. State taxation and regulation of commerce from abroad are also subject to negative commerce clause constraints. In the seminal case of Brown versus Maryland, in the course of striking down a state statute requiring all importers of foreign articles or commodities preparing the selling of goods to take out a license, Chief Justice Marshall developed a lengthy exegesis explaining why the law was void under both the import-export clause and the commerce clause. According to the Chief Justice, an inseparable part of the right to import was the right to sell, and a tax on the sale of an article is a tax on the article itself. Thus, the taxing power of the states did not extend in any form to imports from abroad so long as they remained the property of the importer in his warehouse in original form or package. So if someone sends something overseas and they're still holding it, the state doesn't have the authority to tax it. There you go. That's an interesting one. All right. Powers to regulate commerce. I'd like to see if it says anything about the states and motor vehicles. What's it say about that? I mean, it definitely allows them. But let's see. The only problem with this is there is no table of contents, so we can't really see. Is there? There isn't one. It's so annoying. Actually, is there? Let's see. What's this? Nope, that's not it. What's this? Title page. Oh, maybe this is it. Yeah, never mind. Ah, here we go. Now this is it. Okay, I figured it out. This is the, and then this is the full document here. So that's the full document, but this is the table of contents for it. Oh, that just made my life a lot easier. Thank goodness. All right, so which amendment should we look at here? All right, let's look at this Ninth Amendment. All right, the Ninth Amendment is really, really powerful, and it's not used. It's almost not used at all. Okay, now the Ninth Amendment, and I love the Ninth Amendment. It is by far probably my favorite amendment because it's interpreted by each individual man or woman on its own, and it is open for each man and woman to interpret it. As such, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And that means that if you have a right, if you feel that you have a right, then it's your right. And nobody can tell you otherwise. Unless you're right, if you think that a right is to harm another, then it's not a right. Outside of that, it's your right. That's it. You're free. Okay? I have a right to be left alone. Yes, you do. In fact, the Supreme Court has even said that the right of the people to be let alone. So, yes, that's a right as well. If you want the government to leave you alone, you have that right to have them leave you alone. Leave me alone. I don't want any involvement with you guys. Leave me alone. And they're supposed to do that. Do they? No, because they're freaking money-grubbing bitches. Right? We got to get money from you for this, for that, for everything. You got a house? You got to give us money. You got a car? You got to give us money. You got a job? You got to give us money. You want to buy something from the store? You got to give us money. Right? It's all about money for them. And then if you say no, then they get their goons, hired goons, to come and kick your ass and then force you into compliance. Right? That's a big gross violation of the Ninth Amendment. All you're trying to do is be left alone. All right, so rights retained by the people. Aside from the contending that a Bill of Rights was unnecessary, the Federalists responded to these opposing ratification of the Constitution because of the lack of a Declaration of Fundamental Rights by arguing that inasmuch as it would be impossible to list all the rights, it would be dangerous to list some because there would be those who would seize on the absence of the omitted rights to assert that the government was unrestrained as to those. That is exactly what has happened today. Because there's all these rights that we have that are left unmentioned, the government has seized those rights away from the people. Totally happened. That's exactly, those guys were right. Okay? They were 100% right. And anyone who, yeah, Eric, we're live on YouTube right now. Anyone who doesn't see that, I don't know, you've been living under a rock or something, but yeah, but this is what's going on. Okay. All right. Madison averted to this argument in presenting his proposed amendments to the House of Representatives. It has been objected also against a Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in that enumeration, that it might follow by implication that those rights were not singled out and were intended to be as assigned into the hands of the general government and were consequently insecure. And it says this is one of the most plausible arguments I've ever heard against the admission of Bill of Rights in the system, right? But yeah, you know, it's funny because that is exactly what is going on, right? Like you have a right to travel, okay? And the courts will they will destroy your life if you tell them that. But it's written inside the laws. It's in the treaties with different Native Americans. Well, the Native American tribes have the right to travel in common with the citizens of the United States. Well, bingo, says it right there. Okay. By the way, when they said citizens of the United States, that was in 1855, meaning that there was no such thing as a federal citizen yet. So when they said citizens of the United States, they were referring to state citizens. Okay, and there's other court cases. I got to do another one. There's another court case I think I did on TikTok, but I'll do a formal one talking about what right a U.S. citizen has. He only really has one. All right, 14th Amendment citizen. All right, I conceive that may be guarded against. I have attempted as gentlemen may see by turning to the last clause of the fourth resolution. It is clear from its text that, and from Madison's statement, that the amendment states but a rule of construction making clear that a Bill of Rights might not be by implication be taken to increase the powers of national government in areas not enumerated and does not contain within itself any guarantee of a right or prescription of an infringement. Recently, however, the amendment has been construed to be positive affirmation of the existence of rights which are not enumerated, but which are nonetheless protected by other provisions. Okay. Yeah, so they do recognize it, but they rarely use it. And in fact, here, the Ninth Amendment has been mentioned infrequently in decisions of the Supreme Court until it became the subject of some exegesis by several of the justices in Griswold versus Connecticut. There, a statute prohibiting use of contraceptives was voided as an infringement of the right of marital privacy. Oh, marital privacy is all right. So what are these marriage certificates, marriage licenses? That makes your marriage public, doesn't it? But you have a right to marital privacy. But all these licenses, marriage licenses, doesn't even make any sense, right? Like you have to go to the state to get permission to get married. That's caused a lot of problems. Okay, that's caused a lot of problems for like same-sex marriages. Okay, I don't know how to say it on TikTok without getting banned, but it's caused problems for those people, right? So if they just did away with the marriage licenses altogether, then that whole issue would be gone. Poof, magic. So I don't really care if you go that way. It doesn't matter to me because it doesn't affect me because you have the right to marital privacy, right? You do what you want behind closed doors. All right, that's fine. Okay, I don't care, right? But that marriage license, right, is an infringement of the right of marital privacy. All right, Justice Douglas, writing the opinion of the court, asserted that the specific guarantees in the Bill of Rights have prenumbers formed by emanations from those guarantees that help give them life and substance. Thus, while privacy is nowhere mentioned, it is one of the values served and protected by the First Amendment through its protection of associational rights, and by the Third and Fourth and Fifth Amendments as well. The justice recurred to the text of the Ninth Amendment, apparently to support the thought that the prenumbral rights are protected by one amendment or a complex of amendments, despite the absence of a specific reference. All right, Justice Goldberg, concurring, devoted several pages to that amendment. All right, now this is what's really cool, because what these guys are doing is saying, yeah, there are a lot of rights that we never mentioned, but they are, associated by the Third, Fourth, Fifth Amendments as well. So by association, we can evaluate what other rights you have by the rights that are already delegated. So there's a lot of things they can do with this stuff, right? The language and history of the Ninth Amendment reveal that the framers of the Constitution believed that there are additional fundamental rights protected from government infringement, which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments. First 8. Okay, now notice, and people think like each amendment is one right. I think only the Third Amendment lists one right. I think, and the Seventh Amendment is one right as well. But like the First Amendment has like 4 or 5 rights in there, right? The Second Amendment has, there's 2 rights in there: for militias, right, and the right to bear arms. Okay, the Third Amendment, no soldiers in the house. That's it, right? Fourth Amendment has a bunch of rights in there. The whole thing about warrants, probable cause, right? Searches and seizures, which, Terry v. Ohio kind of ruined. It screwed that up a bit. Terry v. Ohio is a court case where the Supreme Court adjudicated that your Fourth Amendment right was limited because you're in a car or something, right? So they have exigent circumstances where the cops can infringe on your Fourth Amendment right, and it's okay. All right. I can understand in certain situations, but they took it out of this little category of where they can violate that right and kind of broaden it over the years. And now it's kind of overlapping the rights completely, right? And that's what they do. So they very gradiently expand on something, right? Little by little, so no one complains, right? No one complains, no one complains, no one complains, and someone goes, wait, what the hell is going on here? This has gotten pretty out of hand. You go, well, it's too late now, right? That's how they play this game, right? So, like, by the time the next generation is born, this thing that was here to them is now this big, and they just see it as, oh, okay, that's just how it is, right? That's why they play the long game, people, all right? Just realize that. That's what they're doing. To hold that a right is so basic and fundamental and so deep rooted in our society as the right of privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments to the Constitution. It is to ignore the 9th Amendment and to give it no effect whatsoever. So look at that. If they say, well, you know, the first 8 amendments say this, and then the 9th Amendment's being ignored. And I've made that argument before regarding the 8th Amendment and the 9th Amendment in a court case in New York City years ago. And the judge, she kind of goes, well, I mean, well, you know, this is how we do things in New York City. And, you know, because they wanted to give me surcharges on top of fines, on top of other fines with other surcharges. And I was like, this is ridiculous. Like, this is one stupid traffic infraction, and I have to pay like $1,800 for a traffic infraction because of all these different surcharges that go along with this. Like, that's an infringement of the 8th Amendment. The 9th Amendment is being infringed upon because I have a right. And you're telling me you're denying rights to me. So, don't they have to have a specific concern to use? Well, yes, but the whole thing about the Terry v. Ohio thing is that, like I was saying, they've expanded its use in society more and more. So, and the courts allow it and continue to allow it. What it's doing is it's damaging our country's record, right? And I think this is the thing, like, these guys don't get. They're so corrupt and so blinded by their corruption and greed that they don't see that what they're doing is tainting the record, you know, of America. And what they've done is totally destroyed whatever was left of the common law by doing stuff like that. So anytime you use court cases, there's tons and tons of court cases that are used by these corrupt judges, prosecutors, allowing all this, you know, infringement of the rights to continue going on and justifying it. If you contest it, you can always contest it. Yeah. Right. And it may hold up if you make a really good point and the judge goes, oh, okay. You know, but you gotta make a good point about it. Okay. So like the Terry v. Ohio thing was kind of weird because the guys had like guns sticking out of their pockets, right? Or something like that. And it was like pretty obvious that these guys were like armed and it was kind of weird. So the cops were like, all right, get out. Right. Which I don't know. I would instruct them to keep their hands up, you know, really. And that's it. In that sense, you know, keep your hands up and then, you know, you don't have that problem. Right. So it's a gray area. It really is. And I get why they had trouble with it. If there was a guy on the bench who legitimately wanted to uphold and protect people's rights and is looking at a situation like that, he would have a hard time, you know, trying to figure out, well, what's the right course of action here? Because actually, no, I think Terry, well, we have to look at it again, but I think they thought these guys were like scoping out a place to rob or something like that. And then but they had guns on them. I remember that. All right. Moreover, a judicial construction that this fundamental right is not protected by the Constitution because it is not mentioned in explicit terms by one of the First Amendment, 8 amendments, or elsewhere in the Constitution would violate the 9th Amendment. Nor do I mean to state that the 9th Amendment constitutes an independent source of right protected from infringement by either the states or federal government. Rather, the 9th Amendment shows a belief of the Constitution's authors that fundamental rights exist that are not expressly enumerated in the first 8 and an intent that the list of rights included there not be deemed exhaustive. So basically the reason why they wrote the 9th Amendment was because they didn't want to do this endless writing of rights. You know, like in actuality, how long would that go on for? Right? They would have to continuously writing a new amendment. Oh yeah, by the way, you have this right. Oh, by the way, you have this right. By the way, you have this right. The 9th Amendment covers everything, right? You have a right to travel. People keep using the 14th Amendment. That's BS. Don't use the 14th Amendment for a right to travel. The Ninth Amendment covers it already. You have free ingress and regress to each state. That's traveling. How do you travel? However, by the ordinary means of today. All right. While therefore neither opinion sought to make the Ninth Amendment a substantive source of constitutional guarantees, both did read it as indicating a function of the courts to interpret a veto over legislation and executive efforts to abridge other fundamental rights. Okay? So you see what they're doing, right? They didn't want to make it a substantive source of constitutional guarantees, right? But it's a function of the courts to interpose a veto over legislative and executive efforts to abridge other fundamental rights. So when they start making legislation, you feel, hey, that's going to kind of like get in the right, like, okay, like the Obamacare thing, right? I'm going to bring this up because what it did was it forced people to buy health care even if they didn't want to. Well, you have a right to choose, right? Do you not have the right to choose? And they were taking that away. Now, there is no expressly written, amendment to the Constitution or saying that you have the right to choose, but it is a natural right. By the laws of nature, you have the right to choose. If I put an apple and orange in front of you, right, when you're hungry, I say, here, you have an apple, you have an orange. Which one are you going to take? You have, if I say, no, you can't touch that orange, you can only eat the apple. Well, did I take away your right to choose? Yeah. So you have the right to choose. It's there. It's that's why not everyone likes chocolate ice cream. Some people like vanilla. And some people like whatever. I like butter pecan, whatever. You have the right to choose. In a communist country, there is no choosing because the state regulates everything and they own everything. So there is no choice. Okay. But we still have power of choice here. All right. In this case, both opinions seem to concur that fundamental right claimed and upheld was derivative of several express rights, and in this case, really, the Ninth Amendment added almost nothing to the argument. But if there is a claim of a fundamental right which cannot reasonably be derived from one of the provisions of the Bill of Rights, even with the Ninth Amendment, how is the court to determine, first, that it is fundamental, and second, that it is protected from abridgment? See? Now that's a good question. That's a good question. How is it protected from abridgment? Right? And here, let's see what they say. They say nothing. That was it. All right. So they don't even know. They never figured that out. These guys are, well, so what should they do? Well, let's look at this. We can figure it out right here, right now. It's real easy. All right. How is the court to determine first if it is fundamental? It's real easy to determine whether a right is fundamental. Something that aids one's survival, right, in any way, shape, or form, right, is a right. If something is going to help your survival, then it is a right. So if you saying, well, me holding on to my full paycheck without it being deducted for taxes, that's going to help my survival. Well, then that's a right. It's real simple. That's your property. That's property rights. Okay? Would you traded your time and labor, right, for currency so that way you can pay your bills, right? All that stuff. Right? But look at anything that would be pro-survival, something that's going to aid the survival of you, your family, your friends, your groups, whoever, right? All those things would be a fundamental right. Anything that you can do that's going to aid or increase the survival of would be a fundamental right. And is it protected from abridgment? Well, let's see. If that right has the ability to harm somebody in the exercise of that right, should there be abridgment? Yes, because then that means if your right is pro-survival to some and contra survival to others, then there needs to be an abridgment of it in order to keep that level, right? You're trying to keep that balance. That is what justice is supposed to be. It's supposed to be about balance. So in order to protect it from abridgment, there must be, there has to be, if it's going to harm somebody, if you exercise that right too overly, right, then you have to kind of abridge it to some degree. Okay. Um, but that's only if that right is, in the exercise of that right, does it reduce someone else's survival. That's the only time there would be an abridgment of it. So there's really not many rights out there that would actually need abridgment. Okay. And then, so most rights would be protected from abridgment. Right? I can't really think off the top of my head of something that would need to be a right that would need to be abridged in order to protect the survival of others. Right. But that I think if we wrote that down and said that this is how you need to determine whether a right is fundamental, right, and that if it could be protected from abridgment, it's a very simple formula. I just came up with it right now. See how easy that was. I don't know why these guys who are these sophisticated scholars, right, can't figure that shit out. I figured it out in fucking 15 seconds. Why was this so complicated? All right. Chief Justice Warren and Justice Brennan joined this opinion. Justin Harlan and White concurred without alluding to the Ninth Amendment, but instead basing their conclusions of substantive due process, find that the state violates basic values implicit in the concept of ordered liberty. Oh, that's cool. It would appear that the source of fundamental rights to which Justice Douglas and Goldberg referred must be found in a concept of substantive due process, despite the former's express rejection of this ground. All right. Justice Black viewed the Ninth Amendment ground as essentially a variation of the due process argument, under which justices claimed the right to void legislation as irrational, unreasonable, or offensive without finding any violation of an express constitutional provision. Oh, that's an interesting one, isn't it? Right? You have the right to void legislation. Where's Hambone when we need this guy? Because he's over here saying that only a court can do this. But it says here you have the right to void legislation as irrational, unreasonable, or offensive without finding any violation of an express constitutional provision. Wow. So it doesn't have to violate. It could be irrational, unreasonable, or offensive. I like that. That's a good one. All right. So we got some people here in the meeting here. By the way, I decided something because of the scammer coming in. What I'm going to do in the future is I'm going to share the link only within the trust community. So the people who can join the lives here will be in the trust community exclusively, just for the sake, because I'd like to keep all this discussion open and stuff like that. But because of the scammer putting all this nasty stuff up on YouTube in the group, right, it's kind of hard to figure out where he is and stuff like that. So we'll get somebody to go get it. But yeah, that's what we're gonna do. That was my solution. But let's go back to this document. You guys like this document? Like what we're doing here? And I think this is great stuff that we're looking at here. All right. What other amendment we're gonna look at now? I mean, 18th Amendment's gone. That was repealed. Okay, by the 21st Amendment. See, repeal of 18th Amendment. So I'm reading from govinfo.gov. All right, this is called Constitution of the United States of America Analysis and Interpretation 2002 edition. All right, so this is a government website, and it's entire. This is what I do. I don't go on these like these guys who like create these little booklets and read all their theories. Let's read the real shit. Let's read what these guys are recognizing, because that's where your power is. Your power is in understanding how these guys think and operate and utilizing their thinking modes and operating basis to beat them at their game. You got to beat these guys at their own game. Know the game that they're playing, because if you understand the trap and the mechanism of the trap, then you don't fall into the trap. Mice get caught in the trap because they don't understand the mechanism of the trap. Okay, they see a piece of cheese and they go for it. Ah, gotcha, right? Like the government says, hey, we got benefits for you. Really? Oh, I want some benefits. Gotcha. That's the mousetrap. Benefits, right? You know, so it's a mousetrap. But if you understand how the trap is set up, you won't set it off, and you don't get put into the trap. So if anybody goes out there and tells you, yes, owe a duty, you owe a duty. If you take a benefit, you owe a duty, right? Which means you're gonna have to waive a right somewhere, right? Thank you for bringing that up. That's very important. Um, but now this is a really important thing here, right? Like when we're looking at this and understanding that, I see all these people say, "Why are you reading their stuff? That's their stuff." Okay, well, don't you want to know how the trap is set up? So don't listen to those people who tell you shit like, "Don't read their stuff." Those people are detractors, and they're trying to get you to stay uneducated. They don't want you to know how the trap is built. Okay, and those people are not your friends. They're going to pretend to be your friends all day long. Oh yeah, they'll also recommend, oh, why would you go to court? They don't have jurisdiction. Just don't go. And then they're going to put a warrant out for your arrest. And then you're going to be freaking out. Oh my God, they put a warrant out for my arrest. What do I do? Like, well, why didn't you go to court? Well, this guy said I didn't have to because they don't have jurisdiction. They got hired goons with guns that will come to your house and take you away. Just because they don't have jurisdiction doesn't mean that they don't have enforcement. They have enforcement. Anyway, let's do this. All right, so we got all these. We can look at all these different things, right? This is the whole thing. Proposed amendments not ratified by the states. Oh, let's look at that one. Proposed amendments not ratified by the states. I'm excited about this one. Let's see. All right. Good morning. I see you there on YouTube, so good morning. I know I'm a little, the YouTube one I keep missing a little bit. I don't want to ignore you guys, but I'm glad you guys are hanging out over there on YouTube world. And I'm trying to not ignore you, but I got so much going on. I got all these different chats up at the same time. So thanks for hanging out with us. And we're going to keep going. Proposed amendments not ratified by the states. During the course of our history, in addition to the 27 amendments which have been ratified by the required 3/4 of the state, 6 other amendments have been submitted to the states but have not been ratified by them. Beginning with the proposed 18th Amendment, I'm surprised. Congress has customarily included a provision requiring ratification within 7 years from the time of submission to the states. Supreme Court in Coleman v. Miller declared that the question of the reasonableness of the time within which a sufficient number of states must act is a political question to be determined by the Congress. Just a side note to everybody, I will be live tomorrow morning as well on YouTube and Zoom. So meet up again tomorrow and let's join in for another live. And if you guys have anything you want to go over tomorrow, we'll go on that tomorrow. Yeah, exactly. They scare you with enforcement. We let that punishment happen. That's exactly right. Yeah. All right. In 1789, at the time of submission of the Bill of Rights, 12 proposed amendments were submitted to the states. Of these, Articles 1 through 12 were ratified and became the first 10 amendments to the Constitution. Yeah, I remember reading that and I was like, what the heck is this? There's like 12 amendments. There's not 10. And then I realized that they mushed some of them together. Like I think the First Amendment was actually like separated out a little bit. I think the Eighth Amendment was split out a little bit or something like that. So, like 2 of them were kind of split out into other articles. All right. The following text of proposed Article 1. After enumeration required by the first article of the Constitution, there shall be 1 representative for every 30,000. Until the number shall amount to 100. Oh, I see why they didn't do this. All right. It was going to be kind of hard because then for the census, they would have to do this. By the way, this is why the census is a legitimate de jure part of the government, right? Because they need to know how many Americans are in a certain area, so that way they know how many votes, right, or how many electoral votes one state gets, counties get, and stuff like that. That's the reason for the census. That's the legitimate reason for the census. Okay. Other than that, there really is no other purpose. They just need to know the voting power of each county and state, right? That's what it comes down to. All right. And that's part of the republic function. Hey, someone said my name. Oh, yeah. No, I don't. I'm not a voter. I've never even enrolled to vote. When I was 18, we went into high school. In high school, they called all the 18-year-olds to come in and do the voter registration. And I was like, I don't think I want to do this. They're like, oh, you have to. I'm like, I have to? They're like, yeah, you have to. I'm like, so you're telling me that I have to register to vote? They're like, yes, you have to register to vote. I said, do you not see the hypocrisy in that sentence? And I think it was the vice principal. He goes, I'm not. What do you mean? I was like, you want me to make decisions for the United States government, right? He's like, well, you'd be voting for people to make those decisions for you. And I'm like, right. So I'm choosing who I pick to represent me. And he's like, right. And I go, okay, but I don't have a choice in whether I even get to choose someone or not choose at all. He's like, just fill out the damn registration. That's what he said to me. He got frustrated. He said, just fill it out. And so I took my time and never got it done. So I never registered to vote. turns out, it was actually an interesting thing because voting is actually a franchise. It's always been a franchise. It was not actually a right delegated to all the people. It was only for, there's the sexist part about men. Okay, only men over 21 years of age, right, can vote in elections, and they have to own land. Those were the settings. Oh, and they could only be white. That was the whole thing. So the BS about the white and being a man, that was BS. The age thing, I kind of agree with because 18-year-olds should not be freaking voting in elections because they don't know jack. And the fact is that most people nowadays don't own property. Most of the, especially 18, 19, 20-year-olds, they don't own property. And thus really what they're doing is by like the cities, especially the cities where people really don't own any property, they're making huge decisions for the country without any skin in the game. Right. So they make all these they do all these elections and stuff like that. And they're mostly just stupid because they don't have any skin in the game. That's why the voting thing was not considered a right for a long time. Okay. It was really considered a franchise, which is a special permissive right. Okay. Anyway, let's see. That's the problem with the government corporation. Yeah, that's right. Yeah, the government. Exactly. Eric on YouTube. Perfect. Yeah. The government taking over the education system created stuff like that. They forced people to go vote, right? Eldermen. They force people to go vote. They force people to do things like that. And then they make these uneducated decisions for the entire country. Pick this guy because he cares. Oh, he cares. Oh, I like the guy who cares. Don't pick him because he's bad, right? But I mean, the whole thing's Hollywood anyway. Really, all the voting stuff today, it's all Hollywood. That's how I call it, like political Hollywood. And that's how I've seen it for many, many years. I haven't, I remember watching it was Obama and what's that guy's name? It was Obama's second term. I was watching it. I was like, man, that guy, Mitt Romney, that's who it was. I was watching their debates and I was like, Mitt Romney's such a fucking, what a wimp. The guy was like so like, "Oh, I don't want to disrespect Obama. I'm gonna be super nice to him." Like, no, fuck that dude, and fuck Romney too. Fuck all those guys, right? If it was me up on there, I would have been like, "No, you're a bitch. You're a piece of shit. You're trying to take away people's rights, and you're using your niceness to cloud people's judgment about all the evil shit you've been doing." All right, and but they wouldn't let someone like me up on there. That would never happen. Right? No, you don't own property if you got to pay for it. Because remember, all property there used to be full, complete ownership of something. But what they've done by using trust law is they've split ownership into two parts, legal and equitable. And because there's two parts to this thing, and obviously the legal side means that it's whoever owns it legally, it's in your name. Equitable means you get money from it. So who has equitable title to the house, to the car? right? To your paycheck. It's not you. You're not making money off of that. But that's what they've done. And see, and this is the other thing. And all these people in this patriot sovereignty movement, they all have the whole concept reversed. They go, "Oh, you have equitable title and not legal title." No, you're fucking wrong, people. Go read the definitions. Legal title means it's in your name. Equitable title means you make money from it. It's really simple. I don't know how people mess that one up. Isn't voting only for district criminals? District of criminals? Yeah, it's a district criminals. Okay. Well, I mean, there is a legitimate side to voting. The problem is that most of the people who vote nowadays really don't have, like I said, skin in the game. They don't have like something of value for them to adjudicate who is the right man or woman to be voting for, right? And we don't have any good people running anyway. We got a bunch of scoundrels running, right? And what they've done. See, okay, here's the thing. Let me show this off for a second. I'm gonna make a point here. George Washington, when they elected him president, he refused a paycheck at first. And they said, no, you have to get paid. You have to take a paycheck. And he goes, no. This is my duty now. I have a duty. And they said, look, George Washington had money. He wasn't poor. Okay. So he was able to take a paycheck, but they convinced him to take one. They said, look, take it, because otherwise what's going to happen is that they're going to feel only the privileged and rich people would be able to run for office. And we don't want that. And that's when he goes, oh, you know what? That makes sense. All right, I'll take a paycheck. Because he realized that by doing that, he was turning the presidency into a specialized office that only wealthy people would be able to have if there was no, paycheck for them. So that's why he took a paycheck. And, that's, yeah. Oh, yeah, by the way, yes, locally voting for sheriffs is really, I support doing stuff like that, like the local elections. Okay. And you can do those local elections as a state citizen, right? But voting for sheriff, I think, is an important thing, right? Because that's how you exercise your power. The federal government really is just a bunch of trash. Look what they've done. They have no concerns with the American people at all. Their concern is with making sure that all these other countries get shitloads of money so that way they can launder it back into their pockets one way or another. Okay, that's what they're doing. All right. How do you do it without registering? Well, you have to register as an elector rather than a voter. Okay. So if you say, yes, I'm a citizen of the state, I do inhabit the state, but I'm not a resident, right? Because residency is how they get you. Residency means you're there for the duty, to execute a duty, right? A job. That's what residency is, right? Like a resident doctor, right? He's staying at the hospital to do his duties. Resident. And people like that goes over people's heads sometimes. I find that fascinating. But what you would do is you would become an elector. Okay. But it is a little bit tricky. So you make sure, like, do the research on it before you go and try to do it. So that way in your state and county, when you go and register to be an elector, that you're properly set up as an elector, not a voter, and not a U.S. citizen or a resident of the United States. Okay. If you're a state citizen, can you vacation outside of the United States? Of course you can. Of course. State citizens get passports. You know, when you update your passport, what you're doing is becoming a state citizen, right? Or a national. Like the Department of State recognizes the term as national, but the courts recognize it as state citizen. Okay, so it depends on who you're talking to which terminology you should be using. All right. But yeah, that's that whole thing. Now I lost my train of thought. The elector thing. But yeah, the sheriff thing is more important because that's a localized thing. But oh yeah, that's right, because the whole George Washington thing. Now I'm back to where we were. So the thing with George Washington taking the paycheck, right, signified that anybody can become president. Because if a poor man became president and couldn't get paid, he wouldn't be able to hold the office for very long because he wouldn't have any money. He'd be too busy trying to go, make ends meet for his family to be doing the functions of the office. But what they've done today is they've totally destroyed that. One must be very wealthy to really run, okay? Or you have to get a lot of funding and backing, which costs money to even promote that. So the whole thing about running for office requires a ton of uh, currency to do. Okay, there you go. Great work, man. Steve got his passport done. All right, no hassles. He followed my prescribed method, and it worked. Okay, great. Um, so I hope that helps clear that up. So as a state citizen, you get a passport. I can't show it on TikTok because they banned me for one time when I did that, so you can't do that. All right. Now let's see. So that was one article about ratification. These are all resolved by the Senate of the House assembled that the following: if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor. Oh, this is the original 13th Amendment, people. Pay attention. I found it. Okay. This is the original title of nobility. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatsoever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. Man, let's get this one ratified. Let's get this one ratified because you know what this does? This takes literally everybody in government and fucking removes them from government automatically. Right? Right, gone. Bye. Out of here. Because that's what these guys are all doing. They're all doing this. Right? They're accepting, retaining, presenting pension, emolument from a king, emperor, prince, or foreign power. They're going to lose their citizenship. I fucking love that. Why this should be ratified. Let's go. Let's do this. Yeah, you could use Roger Sales. I love Roger. Roger's a great man, very knowledgeable, and you can follow his method. He's good. Yeah, he'll actually be on today in about an hour. His show is going to start in about 1 hour. So if you don't know, well, today's Friday. I don't like the Friday show because it's got Brent Winters. He's the common law lawyer, but he just goes on. He's very religious based. I don't really listen to it. I kind of find some of his stuff. He's very dry, and you know, everybody's got their own taste, right? Like some people like chocolate ice cream. Some people prefer vanilla, right? That's yeah. So I choose to not listen to the Friday shows because I'm not really big on what he goes through, and whatever. All right. Anyway, I like that one. I think that's a good one. The following proposed amendment to the Constitution relating to slavery was signed by the president. It is interesting to note in this connection that this is the only proposed amendment to the Constitution ever signed by the president. The president's signature is considered unnecessary because of the constitutional provisions. No, I'm not co-hosting with you. Upon the occurrence of 2/3 of both houses of Congress, the proposal shall be submitted to the states and shall be ratified by 3/4 of the states. All right. No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere with any state within the domestic institutions thereof, including that of persons held to labor or service by the laws of said state. That's a good one too. Wait a second. Huh. I like that one. I see what they're doing here though. All right. Now, if they pass this one, you know what would have happened? They wouldn't be able to make people get register their cars and shit like that. They wouldn't be able to do that because then persons would be held to labor or service by the laws of the said state. And that's exactly what they're doing. I'll read it again. This is the proposed 13th Amendment, or no, Article 13, sorry. Right? This was related to slavery. It says, no amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or services by the laws of said state. So, no, actually, I think I read that wrong. I'm sorry. This is actually backwards. Um, this was actually a reverse of the slavery thing. This is interesting because what it's saying is that they are going to allow slavery. I read it wrong the first time, so my apologies. You gotta see. This is why it's good to read things again. All right. But yeah, it's saying that the federal government will not interfere with the state holding people to labor or services by laws of said state. So kind of good that that didn't get passed then. All right. So, but yeah, I read it wrong the first time. All right. Resolved by some. Okay. The Congress shall have the power to limit, regulate, and prohibit the labors of person under 18 years of age. The powers of the several states is unimpaired by this article, except that the operation of state laws shall be suspended to the extent necessary to give effect to legislation enacted by Congress. Well, this is a rough one too, huh? Child labor laws. Congress shall have the power to limit, regulate, and prohibit the labors of persons. Child labor laws. I guess they wanted to make it a federal thing, but it's down to the states, really. I think the 10th Amendment is what they used to deny this article. This second proposed amendment to have failed ratification is the Equal Rights Amendment, which formally died June 30th, 1982. Let's see what that one is. All right. The proposed amendment to the Constitution relative to equal rights for men and women. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. This amendment shall take effect 2 years after the date of ratification. Okay. So, I don't know if that's doing anything. I'm in the Telegram group. Okay. But yeah, that's an interesting one. But I can see why they did that, why this one didn't get ratified. Um, I think it was because the Civil Rights Act, right? Um, kind of already covered that, I think. And that's probably why it wasn't. The third proposed amendment relating to representation in Congress for the district of Columbia failed ratification. 16 states having ratified as 1985 expiration date for the ratification period. Okay, so it expired. For purposes of representation in Congress, election of president and vice president, Article 5 of this Constitution, district constituency government. Oh, they tried to make DC a state. That's what they're trying to do. The exercise of rights, powers conferred on this owner shall be held by the people of the district, constituting the seat of government, shall be provided by Congress. Yeah. Okay. Well, that's to make DC a state. That didn't fly. That's it. It's all. Thank goodness we don't need DC being a state. That'd be a world of problems, because then you have, if the District of Columbia became a state, now what happens is that you have internal. Uh, it would be kind of weird. But what happened is that all the U.S. citizens have to move to D.C. I don't know. It'd be weird. I don't know what would happen, but it would just, you would have the federal government now acting as a state, and it would actually violate the separation of states and the federal government, because the federal government is supposed to be an amalgamation of all the states. And if it became its own state, nah, no, that doesn't work. It wouldn't work. That would collapse the entire structure. It's a bad idea. Congressional pay limit. Yeah, then those guys need it. Reduction of voting age. Anyway, so there's a lot of stuff in here. I don't know if anyone has any other recommendations or amendments we can go through on here. Take a look at this analysis interpretation of these amendments. All right. All right, cool. Right to travel. The laws of agency. Oh, yeah, that's a good one. The laws of agency. Actually, I think I have a book on that. We can actually pull up the book, agency. But this is the law of agency. Now we're moved on to a different subject. But agency law is a common law doctrine controlling relationships between agents and principals. A principal-agent relationship is created when the agent is given authority to act on behalf of the principal. Okay, so I'm going to show you what I'm talking about. So you have like, let's say you have a sheriff. Okay, here's a sheriff here. Okay. He's the principal. The sheriff is the principal. What he does is, now he's law enforcement for the entire county. What he does is he takes the power that was given to him, we'll call this power, okay, by the people. They voted for him, so he was given the power by the people, right? This is why the sheriff is actual law enforcement and the police are not, because the police were not elected, but the sheriff was elected, okay? And he's going to delegate that power, which means he's going to give it to his deputies. He says, hey, deputy, I'm going to give you some of this power. This deputy gets some power, right? He's giving these guys, he's delegating this to them. These guys are the agents, okay? An agreement is made by an agent is binding on the principal so long as the agreement was within the authority actually granted to the agent or reasonably perceived by a third party. So in the case of, let's say this deputy here violates your right, right? And harms you in doing so. Now you can sue him, but under the laws of agency, the sheriff is also liable. So you got to sue him too, right? Now, who is the sheriff beholden to, right? He has upper command too, because he's just an agent to a higher authority. And it goes up and up in there. Police are appointed. That's right. They're appointed. They're not elected. So they're not real law enforcement because they do not derive their powers from the people. Okay? That's how you know that you live in a de facto government republic, right? A de facto republic government. It's de facto because if they're not voted in, right? If they're not put in by elections, then it's de facto. The police are supposed to be, if the police are going to be real police and real law enforcement, they have to be elected. Okay? It's the power of the people is what grants them the authority. These guys are just like, you vote for the mayor. The mayor appoints a chief of police. He really shouldn't be doing that. Okay? You should be voting for who's going to be in charge of the law enforcement for your town. You guys should be, that should be a separate election, or a separate thing on the election for the city. You should be able to vote for the chief of police and for the mayor, right? Because they shouldn't be the same. I mean, they're under like one thing, but they should not be the same. And it shouldn't be like if you vote for the mayor, he's going to choose the chief of police and all these guys are going to get appointed, right? That's de facto, all right? And it's not okay. But that is one of the problems. This is why the cops are not accountable, because of the fact that they're operating in a de facto system. They're utilizing this workaround under the laws of agency, all right? But that's the law of agency, and that's how it works. So when if a cop, well, let's just keep looking at this, right? An agreement made by an agent is binding on the principal, right? As long as it was done correctly. there are two forms of actual authority included. Express authority. An agent has express authority to take any action requested by the principal, as well as authority to take any actions inherently necessary to accomplish those requests. Okay? So that's express authority. You can do this, but you can't do that. Okay? That's express authority. Okay? Any actions inherently necessary to accomplish those requests. Implied authority, an agent has implied authority to take any action that principal's conduct indicates the agent should do. Furthermore, failure by the principal to object to an agent's prior actions may create implied authority. See that? So if a guy does something and that maybe he shouldn't have done, right? Like he didn't really have the authority to do it, but the principal doesn't say anything about it, it's implied that now he has that authority to do it. It may create implied authority to repeat those actions in the future. An agent does not have implied authority to do anything expressly prohibited by the principal. So if the principal is not allowed to do something and the agent for the principal does that thing, well, guess what? He's acting outside of his delegated authority, meaning that now he's acting in his own personal private capacity and pretending to utilize a power he doesn't have. All right, good morning. Good morning, people. But yeah, in addition to actual authority, a principal may be bound by actions of an agent if apparent authority existed. All right. By the way, this is stuff like, think about how you can utilize this, okay? There's many different ways to utilize this. A judge is under the Secretary of State and does not actually have discretion, okay? I made a video yesterday on Rumble about fiction of law, and I've showed how they use fiction of law in order to force judges into ruling certain ways, okay? So that way they can't break the status quo, all right? But this is an apparent authority. So this kind of works in this way when we're talking about these agents and stuff like that, right? Know that even though the judge is violating your right, the Secretary of State is the principal over all the judges, meaning that they're bound under the laws of agency. So if the judge violates your right and you actually have recourse to go after them, you can go after the Secretary of State as well. Okay? They appointed a coroner. Well, yeah, so that's a problem too. All these appointments. We appointed. No more appointing. All elections. When does qualified immunity? Where does qualified? Oh, 11th Amendment. That's where qualified immunity came from. We'll go to that in a second, but let's look at this apparent authority first, and I'll show you the 11th Amendment. An agency has apparent authority when, despite no existing authority, a third party reasonably infers that someone is authorized to act on the principal's behalf due to the conduct of the principal. Okay? If the principal acts a certain way, and it makes the agent think that he can do this stuff, then all of a sudden he has apparent authority. It's apparent. Unlike actual authority, a principal can be bound by an agent's act made with apparent authority, even if they explicitly stated that the agent could not do that act. Furthermore, a person possessing a widely recognized title like hiring director has apparent authority to accomplish anything a reasonable person would believe that title entails. An agent acting with apparent authority is known as an ostensible agent. Okay? So that means that, yeah, look, principals can be held liable for torts of their agents under the doctrine of this vicarious liability. So look at how this stuff can work, right? You got a prosecutor bringing in false claims into the courtroom, right? Knowing that they're false, and he's pushing it. Well, what happens? Now you can, this is a tort. Here, we'll click on tort so you guys look at what a tort is. But a tort is an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. All right? This is what we should be utilizing rather than 1983 cases as torts, because it is a civil wrong, right? you can't bring criminal charges because you haven't been delegated the authority to do so, right, by the people. You haven't been elected, so you can't bring criminal charges, but you can do torts. Okay, and this is how, if you do this, let's say you do it with the prosecutor, and you can actually go to his superior, because that's his principal, which is the attorney general. So if you go all the way up the line to the attorney general and to the governor, because guess what? The governor's up on that too. You bring it to them because that's the executive division. That's all enforcement, right? You bring it all the way up to the governor, to the attorney general and governor, and you put a tort claim on them in federal court. Well, they got problems, don't they? Right? Because they would all be liable because of what the prosecutor did. That's some serious stuff. Now, if you want the state on your side, though, is you would reach out to the state and say, hey, look, I'm trying to protect you guys. You have a rogue agent over here who's doing all these things that are legal. Now, because of this is an act or omission that gives rise to injury and harm to me. And it amounts to civil wrong for which the courts will impose a liability on. Okay? Now, because of that, and because of the laws of agency, right, you guys are liable as the principal to your agent. Okay? Meaning that you can be held liable for this tort. I would like to protect you from this tort. So what can you do, right, to help me help you? Help me help you. And this is how you can play this game with these guys, because then, I mean, I've literally done this, okay, and this is actually effective. All right, this is actually, I'm not going to go into detail on TikTok, but what I just said here is really effective. It does work. All right, a principal is always liable for torts committed while the agent completes their official responsibilities. Okay, for torts occurring outside of official duties, the liability of the principal depends on whether the agent's tort occurred during a frolic or a detour. A principal is liable for the detours of the agent, but not the frolics. And we'll look at that too real quick. Frolic and detour is a phrase describing actions taken by an employee that fall in varying degrees outside the scope of employment. Generally, a detour constitutes a minor departure from an employee's duties, but is still considered acting within the scope of employment, where a frolic would be a major departure from the scope of employment undertaken for the employee's own benefit. So like an example of that, of a detour and frolic, would be if let's say you're a judge, okay, and no, that's not going to work. Okay, let's say you're a pizza delivery guy, right? Oh yeah, cop taking it. Well, that's a frolic, okay. That's a major departure from the scope of employment, okay. Taking a bribe, but that's not a frolic though in this case. Right? It's like if the cop, let's take a cop, for example, and let's put him on a detour and a frolic. So a cop has the right, he has the ability to enforce certain laws be respected, right? And if he sees that somebody's harming somebody, he can come in and do that. That is his job. He could take a detour. Let's say that he sees like an old lady can't cross this highway, and he stops his car, right? And puts the lights on so that way the woman can cross. Now, this is technically a detour, right? It's a minor departure from his duties, but it's still acting within the scope of his employment as a police officer. He's controlling traffic, even though it's really just to get this old lady across the street, right? It is kind of a detour because he doesn't have to do that, but he's doing it anyway because they would consider that within the scope. Now, a frolic would be if he goes and takes the woman grocery shopping. Lady, get in the car. I'll take you grocery shopping and pay your bills. He's doing this while he's on duty. That's a frolic, because that's a major departure from the scope of employment undertaken for the employee's own benefit. What is he doing? Well, now it's for his own benefit, right? I'm going to feel good about myself because I helped an old lady, right? But yeah, that's what that would be. That's the difference between a frolic and a detour. All right. So a principal is liable for the detours of their agent, but not the frolics. Now you see how that sentence makes more sense now? Okay. And this is why it's important to always know what these terms mean. If you don't know what a term means, stop what you're doing right away and go look it up, because then it's going to make sense. So a principal is liable for detours, but not for the frolics. It makes sense. So imagine if, like, let's say that cop is like taking this woman grocery shopping, doing her groceries, and then like a whole like shootout occurs, right, while that's happening. Or treasurer that takes law into his own hands. Yeah, that's a good example. Thank you. The treasurer takes law into his own hands. So let's say a shootout happens. Now the principal, let's say it's the chief of police, he's not liable for that cop off doing that because it's considered a frolic, right? Um, but let's say he was helping the old lady cross the street, stopping the traffic when that shootout occurred, and he missed it, right? The principal would be liable for that. Okay, that's how that works. All right. The primary considerations many courts use to determine if an act was a frolic or detour include how much control the principal exerts over the agent's actions, who economically benefits from the agent's actions. So keep this is this whole law of agency thing is super super important, especially when dealing with like police, because it's not just the cop. This is why they never get in trouble. This is why people have a hard time with the police, because they don't understand the laws of agency. They don't understand that this ties into all these other people. Okay, it ties into the chief of police, the mayor. Okay, those all those people become liable under this. The mayor's going to say, well, "I got nothing to do with it." Well, you're the principal. Who appointed the chief of police? Well, I did. Okay, and the chief of police appointed this cop. Yeah. Well, you're the agent, you're the principal, the mayor's the real principal in this matter, and the chief of police is an agent. So you hit up all the agents as they go on up. Pretty simple. Okay. All the way up to the principal. So, but that's the laws of agency. Now, what are we taking it? How high on the ladder can you go? Oh, yeah. So, but yeah, that whole thing of reaching out to the top principals and letting them know that they have rogue agents can be effective. All right. Now let's look at this 11th Amendment real quick. Since we're talking about qualified immunity, this 11th Amendment is where, well, there's actually something inside the articles as well. All right, in here, where is it? It's modes of amendment, president, oath of office. I think it's in Article 6, but there is it starts in here. Yeah. Oh no, that's not it. Damn it, where is it? I forget where it is. But there's something in the Constitution itself, but then the 11th Amendment is what they're utilizing for sovereign immunity. Okay. But there is something that says that the legislators and stuff like that, while they're in an official capacity, have immunity. Okay. And it's not full immunity, they have certain immunities. But state immunity. So we're gonna, oh my goodness. Okay, so here's the 11th Amendment. The judicial power of the United States shall not be construed to extend to any suit in law, equity, commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So it's saying that, like, if you're a citizen of California, you can't sue the state of Oregon, but you can still sue the state of California. All right, because you can't sue citizens of another state, right? Or any state. The 11th Amendment jurisprudence has become over the years esoteric and abstruse, and the decisions inconsistent. At the same time, it is a vital element of federal jurisdiction that goes to the very heart of the federal system and affects the allocation of power between the United States and the several states. Because of the centrality of the amendment at the intersection of federal jurisdictional power and accountability of the states and their officers to federal constitutional standards, it has occasioned considerable dispute within and without the court. So there's been a lot of, and it's true, there's a lot of times they go, oh, sovereign immunity, and they go, yeah, you're right, you got it, and then that's it, it's done. And then other times they go, no, you don't have it. So they're right. It goes back and forth a lot. That's what they're talking about in that paragraph. Like, the states will claim sovereign immunity, and it'll get granted or not get granted. So, The action of the Supreme Court in accepting jurisdiction of a suit against a state by a citizen of another state in 1793 provoked such angry reaction in Georgia and such anxieties in other states that the first meeting of Congress following the decision of the 11th Amendment was proposed by an overwhelming vote of both houses and ratified with what was for that day vehement speed. Chisholm had been brought under the part of the jurisdictional provision of Article 3 that authorized cognizance of controversies between state citizens and another state. See, this is what happened. You see, this 11th Amendment was a power trip right from the get-go. See, these guys, as soon as these guys had gotten some kind of authority and found out that they didn't have it, they got fucking pissed and decided to give themselves a power that the Constitution very clearly said you don't have. Right? Because of that whole thing, controversy between a state and a citizen of another state, right? The Supreme Court shall have original jurisdiction over. And they said, no, we don't want this. We don't like this. And then they put the 11th Amendment in and screwed everybody over. This is why all the motor vehicle cases are in municipal courts, because of the 11th Amendment. All right. At the time of the ratification debates, opponents of the proposed Constitution had objected to the subjection of a state to suits in federal courts and had been met with conflicting responses. On the one hand, an admission that the accusation was true and that it was entirely proper so to provide, and on the other hand, that the accusation was false and the clause applied only when a state was the party plaintiff. So you see, they went back and forth like, oh, you can't, only the state can bring the charges at the plaintiff, but they can't be a defendant, and then vice versa. They were defendant and they weren't. So matters stood when Congress, in enacting the Judiciary Act of 1789 without recorded controversy, gave the Supreme Court original jurisdiction of suits between states and citizens of other states. Chisholm versus Georgia was brought under this jurisdictional provision to recover under a contract for supplies executed with the state during the Revolution. 4 of the 5 justices agreed that a state could be sued under this Article 3 jurisdictional provision, and that under Section 13, the Supreme Court properly had original jurisdiction. Right? The amendment proposed by Congress that ratified the states was directed specifically towards overturning the result in Chisholm. You see that? They didn't like the Chisholm result, so they put it in the 11th Amendment because they didn't want the people. They realized that what this Constitution did was it gave people a lot of power. And they said, no. We don't want that. All right? And preventing suits against states by citizens of other states or by citizens or subjects of foreign states. It did not, as other possible versions of the amendment would have done, altogether bar suits against the states and federal courts. By the way, Hambone finally showed up, and he's here talking nonsense because he doesn't read that. He doesn't know that this is coming right off of a government website. And I'm reading exactly what it's written on in here. This is them explaining the 11th Amendment. This is the Supreme Court talking about the 11th Amendment. Okay, so it's not my agreement. It's what they've been saying. So he missed all the good stuff. He missed all the stuff that would have made him slunk in his chair and cry. All right. But yeah, there you go. Okay. So they were so pissed off about that. So if they give you, if they give you a ride home. I think Hambone's lost. He doesn't even know what we're talking about. You're confusing the conversation, so I'm gonna ignore you until you catch up to where we're at. All right, that is it. Barred suits against states based on status of the party plaintiff and did not address the instance of suits based on the nature of the subject matter. Okay, so that's interesting. So you see what they're doing? They're saying, well, this 11th Amendment bars suits against the states based on status, but it doesn't address the situation of suits based on the nature of the subject matter, right? And that's a big problem. That's a pretty big problem right there. That 11th Amendment says, well, we don't care what the subject matter is. You can't sue the state, period. right? Well, that's just a bunch of hurt politicians putting this amendment together in order for them to protect their own asses, right? What do criminals do? They do everything they can to continue criminalizing. And how do they do it? Well, they create the laws to do it. All right, they give themselves immunity. Oh, I'm immune. I'm immune. Who gave it to you? Me? No. All right, the early decision seemed to reflect this understanding of the amendment, although the point was not necessary to the decisions, and thus the language is dictum. In Combs versus Virginia, Chief Justice Marshall ruled for the court that the prosecution of a writ of error to review a judgment of a state court alleged to be in violation of the constitutional laws of the United States did not commence or prosecute a suit against the state, but was simply a continuation of one commenced by the state and thus could be brought under Section 25 of the Judiciary Act of 1789. In the course of the opinion, the Chief Justice attributed adoption of the 11th Amendment not to objections to subjecting states to suits per se, but to well-founded concerns about creditors being able to maintain suits in federal courts for payment, and stated his view that the 11th Amendment did not bar suits against the states under federal question jurisdiction, and did not in any case reach suits against the state by its own citizens. And there you go. That's why you can always sue your state, but you can't sue another state. Okay. Although I think it's BS if you, let's say you're a citizen of Tennessee and you're doing, let's say you have business in Alabama, right? And you're going, or yeah, Alabama, Tennessee, you're going back and forth between the states, and all of a sudden, Alabama, whops you with something, and like maybe some kind of fee or something like that, or a huge tax, and you go, whoa, 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 that's not even part of your legislation, and so you sue them for, let's say they just start taking, money out of your bank account or something like that. They start seizing stuff from you, the state of Alabama, and you're Tennessean. So you would have a legitimate case against them, but you're not allowed to sue them because they're not the state that you're in. That's a big problem. Okay. All right. In Osborne versus Bank of the United States, the court again, through Chief Justice Marshall, held that the Bank of the United States could sue the Treasurer of Ohio over 11th Amendment objections because the plaintiff sought relief against a state officer rather than the state itself. Now, keep that in mind. That's important to realize, is that if you're going to do this, you got to get clever about it. And instead of suing the state itself, you sue the state officer that did it. Okay? And that's a big deal. All right. This ruling embodied two principles, one of which has survived and one of which the Marshall Court itself soon abandoned. The latter holding was that a suit is not won against the state unless the state is a named party of record. The former holding, the primary rationale to which the strictures of the amendment are escaped, is that a state official possesses no official capacity when acting illegally, and thus can derive no protection from an unconstitutional statute of a state. And there you go, people. That is what you're going to use in these proceedings, okay? This is what you would be using, right? If they cannot derive protection from an unconstitutional statute of a state. And this is it. This is everything right here, okay? I shouldn't say everything, but this is a big deal, because what it's saying is that you can't sue this other state. Like in that case of Alabama, let's say you're shipping things to Alabama from Tennessee, and Alabama whops you with this like huge tax bill, and then starts like depleting your bank accounts, saying that, well, we're taking the money because you owe it to us. You got to go after the state officer that's doing it, okay? Because what is he doing is he is violating a right to due process. Like, whoa, you just started taking money out of my bank accounts. You can't just do that. Yes, we can. You owe us the money and we're taking it. Well, you got to sue that guy. And what is he doing? He's acting illegally. A state official possesses no official capacity when acting illegally. If he's violating due process, he's acting illegally. The federal Constitution applies because this is over state borders. And he could derive no protection from an unconstitutional statute of a state. Okay? And that's that. And that's this kind of stuff that we want to be utilizing in this. Maize to remove their cheese. Yeah. All right. Expansion of the immunity of states. Until the period following the Civil War, Chief Justice Marshall understanding of the amendment generally prevailed. But in the aftermath of that conflict, Congress for the first time effectively gave the federal courts general federal question jurisdiction, and a large number of states in the South defaulted upon their revenue bonds in violation of the contract clauses of the Constitution. As bondholders sought relief in federal courts, the Supreme Court gradually worked itself into the position of holding that the 11th Amendment, or more properly speaking of the principles of the amendment, is but an exemplification, is a bar not only of suits against a state by citizens of another state, but also of suits brought in by citizens of that state itself. And you see how they do this? This is how the dwindling spiral works. Remember what I was saying earlier? If you were on earlier, I said they put this little thing in there, and then they slowly expand it. You're looking at the slow expansion of their authority and the slow squashing of your sovereignty. Okay? That's what they're doing. And of course, it's always after the Civil War. Most of this crap happened after the Civil War because everything was in such chaos from the Civil War. I mean, you had brothers fighting brothers. It was crazy. Families divided. It was insane. I don't think people, if you weren't there, like, it's hard to really grasp like what kind of stuff was going on, because Americans were enemies to other Americans. It's like crazy. Yeah, it's still in effect. Yeah, so martial law is still going on. But the Civil War really damaged the country in such a large way that people just, I mean, like I said, like we were all born after the fact, and so we didn't see the changes that occurred in the country. Okay? And war is a great way to hide major change. Okay? You want to create major change in a country, create a war. Okay? And by creating a war, it creates a huge distraction for major change. And it gives them a good justification for the change. Well, because of this war, because of this thing, this is what we need to do. People go, yes, whatever we can do to end this war. This is horrible. Nobody wants to be in a war except for those psychopaths that want more control. Okay? And of course, the guys who make, weapons, right? Big giant weapons, they like war because war was profit for them. Okay. All right. So expansion as a formal holding occurred in Hands versus Louisiana. A suit against the state by a resident of that state brought in federal court under federal question jurisdiction, alleging a violation of the contract clauses and the state's repudiation of its obligation to pay interest on certain bonds. Okay, so you see, this is the bond market collapsing. Okay, and these state citizens are trying to sue, and they go, no, you can't sue your state anymore. That's it. 11th Amendment. And they're like, well, the 11th Amendment doesn't say that, but see how they're just expanding it. So as they, like, if you have rights and they have authority, as they expand their authority, your rights shrink, right? That's what they're doing. This is where I'm going. Okay, he's going somewhere. All right, admitting that the amendment on its face prohibited only the entertaining of a suit against a state by citizens of another state or citizens of subjects of a foreign state, the court nonetheless thought the literal language was an insufficient basis for the decision. Rather, wrote Justice Bradley for the court, the 11th Amendment was a result of the shock of surprise throughout the country at the Chisholm decision, and reflected that determination, I can't say that, Chisholm, that the decision was wrong and that federal jurisdiction did not extend to making defendants of unwilling states. Okay. States have to be willing. Okay, we'll go into a lawsuit with you. Oh, we're not willing to go into a lawsuit. That's like the fuck you clause, right? You know, you could sue the state, but the state could go, you know what, fuck you. And that's it. No more lawsuit, right? We should just call the 11th Amendment the fuck you clause. That's it, right? You know what? Fuck you. You can't sue me. Imagine that. Well, shouldn't we have that kind of power, right? That would be great. You know, like let's say a cop brings charges to you, you know, like for speeding or something, and then the court writes to you and says, yeah, you need to appear on this day for you know, this thing. And I go, you know what? No, I'm not willing to be sued, so never mind. Sorry. Fuck you clause, right? We should have that, right? New amendment to the Constitution. Every citizen of every state has the right to say fuck you to any lawsuit his way if he's unwilling to do that lawsuit. Fuck you. That would be great. All right. Oh. Wait. What does this say? I asked the judge what jurisdiction I was being tried. Common or he said statutory. And great. You say, wow, statutory. Where can I read the statutory procedures? Do you have the rules of statutory procedures on hand for me to look at? Where is that? What the hell is statutory? This is statutory. Really? And what are the statutory rules of procedure? Statutory. Fuck. Yeah, exactly. Yeah, that's their game. Then when demon mode, threatening contempt. Yeah, exactly. Yes, that's because you got on. So guy here on TikTok, Clint, he's talking about, he went to court and asked if this was common law or admiralty, and the judge said it was statutory, and then started threatening him with contempt. I said, this is exactly what they do. They say, oh, you can't be asking these questions. Oh, I'm going to hold you in contempt for asking questions. That's right. But doesn't the state constitution afford me the right to know the nature and causes of the accusations being brought before me? Well, it does, but you can't be asking these questions in court. Oh, okay. Is this like a private court? Is this a private trial or a public trial? Right? Is this a private or public trial? Oh, well, you know, it's public. Oh, why did you make me turn my phone off then? Why you say I can't have my phone on here? They do that in a lot of courts. Turn your phones off, no recording, no this, no that. So what are you doing? Let's see. But yeah, if you very kindly push that issue, then they'll drop it. Okay. But you just ask them, oh, statutory. Oh, do you have a copy of the rules of statutory procedure in hand for me to be educated on so I can study them and understand the procedures that you're using in the statutory court? And he's going to go, well, we use the criminal procedures. Oh, okay, thank you. So it's criminal. Okay. What kind of criminal court is that? Is that common law or admiralty? And you're right back to it. I told you it's statutory. Right. But we've already determined that you're not using statutory procedures because it doesn't exist. So you're now going back to saying that this non-existent jurisdiction exists again. Can you put down, for the record, Your Honor? Right? Okay. Under this review, the amendment reversed an erroneous decision and restored the proper interpretation of the Constitution. The views of the opponents of subjecting states to suit were most sensible and just, and those views apply equally to the present case as to then under discussion. The letter is appealed to now, as it was then, as a ground for sustaining a suit brought by individual against the state. By the way, if you guys want to see, if you're on TikTok and you want to see what I'm looking at, you can either move over to YouTube and watch it there, or what you can do is go to my Telegram, click the Zoom link, and join in on Zoom over there. Okay, those are the ways you can do it. The reasoning against it is as strong in this case as it was in that. It is an attempt to strain the Constitution, the law of construction never imagined, dreamed of. The truth is that the cognizance of suits and actions unknown to the law and forbidden by the law was not contemplated by the Constitution when establishing the judicial power of the United States. The suability of a state without its consent was a thing unknown to law. Okay, that Chisholm case, it scared the shit out of those guys because they realized that the state does not have as much power as the people. That's what it did. It scared the living shit out of them. Thus, while the literal terms of amendment did not so provide the manner in which Chisholm was received by the country, the adoption of the 11th Amendment, the light of history and the reason of the thing, led the court unanimously to hold that states could not be sued by their own citizens on grounds arising under the Constitution and laws of the United States. This is why I keep telling you people, you got to use the state constitution. Stop using the federal constitution in these court cases. Use the state constitution. They can't tell you no to that. They can say no to the federal constitution because of that principle right there. All right. For the record and evidence. There you go. All right. But that's exactly why you got to use the state constitution and the state laws. You got to use the state stuff. Okay. Because of this 11th Amendment. It held that the states could not be sued on their own citizens, by their own citizens on the ground arising on the constitutional laws of the United States. Why? And I'm going to tell you why. Because as a state citizen, right, you're beholden to your state. That's your country. So those are the rules. When it goes to other states, you can sue another state under the Constitution because it's federal. It's cross state lines. Okay? But the 11th Amendment prohibits you from doing it, which is a violation of your rights under the Constitution. So the 11th Amendment, like I've been saying for a long time, is a BS amendment and needs to get rid of. Okay? This is what they're utilizing all the time. Okay? All right. Then Ex parte New York, the court held that absent consent to suit, a state was immune to suit in admiralty. The 11th Amendment reference was any suit in law or equity, notwithstanding. That a state may not be sued without his consent as a fundamental rule of jurisprudence, of which amendment is but an exemplification. It is true the amendment speaks only of suits in law or equity, but this is because the amendment was the outcome of a purpose to set aside the effective decision of this court, the Chisholm case. See these dots right here? These dots are telling you that there's more information in there, but they left it out. Okay? So there is more data inside of here. Okay? But it's not there. They left it out. That's what those dots mean. So, you see, it's all in here. So they may have left it out. You would have to, if you want to know, you have to read this ex parte thing because that's where it comes from. Okay. But if it may be left out just because it doesn't really matter for the text. Yeah, every single state constitution has nature and cause in it. So you have that right to know nature and cause. From which it naturally came to pass the language of the amendment was particularly phrased so as to reverse the construction adopted in that case. All right. This is a big one too. We're not going to read all this. There's so much stuff in here. The Hans v. Louisiana has demonstrated the impropriety of construing the amendment so as to permit federal question suits against the state. So it seems to us equally clear that it cannot with propriety be construed to leave open a suit against the state in admiralty jurisdiction by individuals. Right? So you can't sue them under admiralty either. Right? Even though it doesn't say that in the 11th Amendment. It says, well, we're going to extend it. See what I mean? You see the pattern here now, people? They're continuously extending it out, right? They're just broadening it, making it broader and broader and broader. That's the game that they play. Okay? This is what, you guys should not be shocked seeing this anymore. When they do this now and the legislation doing it, just think about how are they expanding their powers and limiting your sovereignty and your freedom and your rights, right? They are doing that. So how are they doing it? Okay, that's how they do it. Just these little things, right? So first, the 11th Amendment says you can't sue them in law and equity. Now this case says, well, we're going to also add in admiralty. So I went from here to here, right? It's a problem. And in rem means like property. It's about property rights. All right. In rem admiralty action may be brought, however, if the state is not in possession of the res, the property. Interesting. Okay. In extending protection against suits brought by foreign governments, the court made clear that immunity flowed not from the 11th Amendment, but from the concepts of state sovereignty and immunity generally, sovereign immunity generally. Manifestly, we cannot assume that the latter of the 11th Amendment exhausts the restrictions upon suits against non-consenting states. Behind the words of the constitutional provisions are postulates which limit and control. There is the postulate that states of the Union still possessing attributes of sovereignty shall be immune from suits without their consent, save where there has been a surrender of this immunity in the plan of the convention. All right. Oh, we're gonna surrender our immunity. Yeah, right. Okay. The states, but now where does the state of the Union get its sovereign powers from? Little clue. It's in your state constitution. We're gonna play this game. Someone give me a state, either on TikTok, YouTube, or in Zoom. Someone give me a state. Florida. We're gonna do Florida. Florida Constitution. And here it is. Florida Constitution. So it's to California. We got Wyoming, Kansas. We did Kansas yesterday. Okay, preamble. We, the people of the state of Florida, being grateful to Almighty God for our constitutional liberty. Oh, where did it come from? In order to secure its benefits, perfect our government, ensure domestic tranquility, maintain public order, and guarantee equal civil and political rights to all, do ordain and establish this Constitution. So let's look at Article 1, political power. All political power is inherent in the people. The enunciation herein of certain rights shall not be construed to deny or impair others retained by the people. There you go. All right. So, where did they get this power from? The people. Let's look at another one. Let's do the Wisconsin one. Let's do that. We'll do that. Wisconsin. Wisconsin. Let's look at this one. This is fun. This is where, because this is where things get real, you know. All right, we the people of Wisconsin, grateful to Almighty God for our freedom, in order to secure. Was again, we're seeing a theme here, aren't we? Where are these people getting their freedom from? This is a we the people of Wisconsin, grateful to the Almighty state for our freedom. Nope. In order to secure its blessings, form a more perfect government, ensure domestic tranquility, and promote the general welfare, do establish this Constitution. All people are born equally free and independent and have certain inherent rights. Among these are life, liberty, and the pursuit of happiness. To secure these rights, governments are instituted, listen carefully, deriving their just powers from the consent of the governed. It's consensual. Where's Hambone? It's consensual. If when you consent to be governed, that's when you give them the power. So if you do not consent, they don't have authority. Okay, we got California, and then we'll do Hawaii. Okay, so let's do California. I'm trying to go in order. California, because we did Kansas last night, even though it was a different subject. Preamble. Oh, why is it so small? California trying to hide stuff over here. We're going to make the text really tiny so people can't see it. Yeah, that sounds like California, doesn't it? We, the people of the state of California, grateful to Almighty God for our freedom. Oh my goodness. What is this? This is copy and paste day. All right. In order to secure and perpetuate its blessings, do establish this Constitution. Great. So, first thing is, they're getting their rights not from the government, from God, the people, by the way, not persons. Okay. Persons don't have rights, and persons don't convey uh, authority. People do. Notice that they always say that. Never says persons. All right. Now let's look at Declaration of Rights here. All people are by nature free and independent and have inalienable rights. Among those are enjoying and defending life, liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and privacy. So the people are free. Let's see. Is there anything in that? Doesn't say that. Yeah. You can petition the government for redress for grievances. You're allowed to sue the government. Then the state enslaves the person. Yeah, exactly. Enslaves the person. No, but that's about it. But there you go. There it is there. They just don't say where the state gets its authority from in here. They don't want to say that. All right, now we're going to do Hawaii. State Constitution. Revision notes. Let's look at that preamble. We, the people of Hawaii, grateful for divine guidance. Oh, I've never read this one. And mindful of our Hawaiian heritage and uniqueness as an island state, dedicate our efforts to fulfill the philosophy decreed by the Hawaii state motto. I can't say that. I'm sorry. I don't know. Ooh, I'm not even gonna try. But I'm gonna butcher it. All right. We reserve the right to control our destiny, to nurture the integrity of our people and culture, and to preserve the quality of life that we desire. I like that. That's cool. All right. We reserve the right, because remember, Hawaii was its own culture. Okay. So they're preserving their culture here by doing this. All right. We reaffirm our belief in government of the people, by the people, and for the people, and with an understanding and compassionate heart towards all the peoples of the earth, do hereby ordain and establish this Constitution for the state of Hawaii. Okay. All political power of this state is inherent in the people, and the responsibility for the exercise thereof rests with the people. All government is founded on this authority. This is 1978, people. 1978 is when they, because this is a reconstruction of the Constitution. 1978. All government is founded on this authority, the authority of the people. And then they go to persons again. Oh, see that trash. Why do you gotta do that? 14th Amendment persons. Yeah. Isn't that great though? All right. All political power of this state is inherent in the people. But it's also the responsibility of the people. So keep that in mind, okay? You have a responsibility as one of the people. Okay, this isn't like goof around, screw around, fuck everything. You gotta have some responsibility. Meaning that if you're gonna be responsible, you have to have knowledge. Okay, you can't be responsible without knowledge. Okay, and only when you have those two things would you be able to control the situation at hand. You cannot control the situation if you don't have responsibility, and if you don't have any knowledge, you can't truly be responsible for something. So you got to keep that stuff in mind. That's really important. Okay, if there's a responsibility for something, you have the responsibility to know and to have the knowledge, to have the information. Okay, so the responsibility for the exercise of all political power resting with the people means that you, as one of the people, now have a duty to be knowledgeable and use that responsibility with knowledge. Okay, that way you can calmly and effectively control your state government. That's what you need to do. All right. So I think I'm gonna wrap it up for today. But before I go, anyone have any quick questions, comments, or anything like that? We'll take it from Zoom. If you're on Zoom and you have anything you want to say, I'll unmute you and you can ask your question. Nobody? I'm surprised. Everyone's shy today. That's all right. Yes, you're very welcome. What is this? Yes, they're in a big lawsuit for me locking up 70. Oh my goodness, that's crazy. Donald's got some crazy stuff going on YouTube over here. And we got, love these, especially here. Oh, yeah, you're welcome. Yeah, I'm glad to hear that. Thanks for the website to read. Oh, yeah, you're welcome. Yeah, there's a lot of good stuff in there, right? A lot of good stuff. All right. Okay. Nobody on Zoom. What about TikTok? Anyone got anything to say on TikTok before I get out of here? Recouping bum. I'm not gonna. Can't talk about that on TikTok, dude. They'll shut it down if I talk too much about it on there. All right. Yeah. That's Yeah. Well, thank you. I appreciate it. So might as well throw a plug out for community. Oh yes. You want to Yeah, I'll unmute you. You can say something if you want. I'll let you talk. I don't like plugging my own stuff. Other people can do that.
Yeah, Joel. Long time listener, first time caller. um, it is your community is the best, where you get all the information the way it's supposed to be, and it's just great all the way around. So, what I can say, I'm not a speaker, I'm a writer. So,
And no, that's even better. Okay. If you're not a real speaker or writer, just talking about it it makes it even better. Like a speaker or a writer, they can talk stuff up, you know. Those guys are really good at talking things up. But if you're not one of those guys and you're talking from the heart, it's more valuable. It means something. You know, it's real. Because those guys, look at some of these guys, like these politicians, man. They can really talk it up, and they con people, but people don't realize that these guys are trained to be conniving and convincing speakers, right? So, but in the trust community, I will tell you guys this: in the trust community, we do a lot of private processes that cannot be shared in a public venue. Okay. So we've been doing that, and I think a lot of people have been having fun. We've had some very interesting results, right? Very positive. I'm going to say positive, interesting results from people applying some of the stuff that we've been talking about inside the trust community, because it's it is centered around trusts, okay, and everything is about trust, but there are other sections inside this community where we go into other things that kind of branch out of the trust stuff, and it does create all kinds of we've it's been really some interesting stuff has occurred. It's been really cool. So anyone else want to say anything, comments, questions before I go? Where can I study? Oh, well, I do have a Rumble channel. People can study from there, from Rumble channel. If you go to my profile on TikTok, you'll find the link tree link, and then from there you can go find the Rumble. And I link everything. If I can link it, you will have the link. I've been doing that since day one, right? Because I didn't want people to think I was just BSing people, so I always shared the link. All right. Thank you, Brent. All right. But yeah, but in the trust community, by the way, because of the fact that there's so much craziness online and everything's just a big jumbled mess, the trust community does offer something very unique, which is you get a step-by-step gradual increase of information. Okay, you cannot find that anywhere else, really. Okay, it's virtually unheard of inside of this movement of like a gradual increase. Like if you go into the community chat, and people are all over the place. But if you go back and watch all the videos in order, you're gonna get the information from beginning to end. All right, and you'll have a coherent education on the entire subject. That is what the trust community really offers, is we leave no gaps in your understanding. Okay, and I try every meeting to ensure that there are no gaps in anyone's understanding. And usually what we found out, don't worry, it's not for me. Okay, what we usually find out is that the gaps in people's understanding is because they haven't watched all the trust meetings. Okay, and that's usually the problem, is that they haven't if they watch the trust meetings, they usually have a comprehensive understanding. At least I hope so. Right? Did I do good on that one? Has it been working? I hope so. I'm trying here. You know, because I go on TikTok and I'll see people saying stuff like, oh, you gotta talk about principal and agent and all that stuff in terms of like financial contracts. And they're talking over everybody's head, but they're wowing people with information. But half of the stuff they're saying, people just won't understand. It'll take, so they talk about things that are really out of sequence in as far as understanding goes. Okay. And there's a sequence of learning information, right? As a teacher, I'm a music teacher. I've been teaching since the 90s. And over the years, I've put together a really good formula for teaching. And that is basically like, you got to start at a fundamental concept and build from that fundamental concept. And they don't do that in this movement. And that's what I've been doing within the trust community, is we build upon one concept and move it from there. And we gradually build on it piece by piece. Okay. Like I said, there's so much scattered information all over the internet and what people are sharing that it's really hard to keep track of that stuff. That's why I've been doing this. That's why I wanted to do this community, for that purpose of ensuring that there was like, a proper step-by-step understanding of information. Otherwise, it's just a big jumbled mess. My trust is, as you said, to do. I've been around a long time in the rooms. Oh, cool. Wait. Donald Robinette, he's got, yes, they are telling me I need a lawyer is what I'm fighting now. Yeah, you need a lawyer. Yeah, say, well, I can't get a lawyer because your lawyer works for you guys. He's an officer of the court, which means he's beholden to you before me. So if I hire a lawyer, I'm hiring someone who works for you. Should I take it to federal level or stay at the state? Oh, my suggestion, my opinion, what I would personally do, and I'm not telling you, I'm not recommending anything, right? Like, I don't give legal advice. I would take it to federal court. That's what I would do. Okay. Just because the states get a little crazy about this stuff, right? And they start pushing things a little too hard. Taking it to federal can give you some relief and some remedy, right? Yeah, hiring the enemy, exactly. Yeah. So I hope I answered your question. I hope you're still here to hear that question, but get answered. But that's what I would do personally. But I think that's it for me today. What time tomorrow? I think tomorrow I'm going to start at 10. We're going to go from 10 to 12, very strict time. 10 to 12, that's it. I'm out. All right. So tomorrow, if you guys want to see, but I'm only going to be sharing the Zoom link in the trust community. Okay. Because we had all this crazy stuff with the scammer going on, putting up all this nasty stuff online. So I'll only be sharing the link within the trust community. So the only people that are going to get the Zoom link are in the trust community. And if you private message me and not part of the community, and I know you, I will share the link with you as well. All right. Eastern time. Yeah, sorry. Eastern Standard Time, 10 a.m. So Saturday. All right. So guys, thanks for hanging out with me. I appreciate every single one of you. Which channel in the community? Oh, the community chat. I'm gonna put it in the chat where everybody has access to. All right. Okay. Yeah, you can message me. I'll send you the Zoom link. Don't worry, Livy. Um, but yeah, you guys can private message me if you see me on and you want to be on the Zoom call, because I won't put up the restrictions like I did today because of the fact that it was in the Telegram chat. So yeah, thank you guys. No, I appreciate it. Thanks for hanging out with me. And man, it's been, what has it been, like 2 hours, 3 hours? It's been a while. We've been going on for a while. This is a good long meeting today. Anyway, I'll see you guys later. I'm gonna go